All right, I think I'm live. Oh, am I live now? All right, I'm live. Welcome to the live stream, you guys. I am so sorry for being late. I changed the time at the last minute and then was late. So technically I'm early because I was supposed to start at 4:15 and it's 4:07. But anyways, if you guys are watching live, thank you for joining me live. Make sure to hit the like button. And if you're watching on the replay, go ahead and hit the like button as well. If you're watching on live, let me know where you are watching from in the chat. I just got a lot of subscribers today from Legal Bites. So if you are coming over from watching Legal Bites stream all day, thank you for coming to support and let me know that you came from there. All right. So for those of you who do not know what's going on, there is a trial going on between Johnny Depp and Amber Heard for defamation, and there are a couple of law tubers streaming the full day trial. So if you are interested in learning about defamation, or if you're interested in learning about um, Johnny Depp's relationship with Amber Heard, then make sure you go ahead and check out Legal Bites, Emily D. Baker, or Ricada Law. But today, we are going to be taking a little bit of a step back from that. We're going to be focusing on one of my big topics, which is trademark law. So if you are interested in that, go ahead and stay tuned. Again, guys, if you're watching live, let me know where you're watching from. If you have been keeping up with the Johnny Depp trial, let me know what your thoughts are on the case. Today, we are going to be kind of backtracking to a case that I covered last week with Stone Brewing and Miller Coors. I don't know if you guys remember them, but it was to my surprise when I found out that Stone Brewing is also being sued for trademark infringement. So I'm going to give a brief update on that, and then we're going to go ahead and truck right into StockX's response to Nike, who recently filed a lawsuit against them in, I believe, January of this year for making NFTs with the Nike trademark on it. So we're going to go through StockX's answer. If you're interested in knowing what complaints Nike had against StockX, go ahead and check out my video. I covered it along with the NFT trademark lawsuit that was filed against the virtual Hermes Birkin bag that Hermes filed against, basically who they're calling the infringer. So make sure you go back and check out that video if you want to know what the actual complaint said, because today we are going to be covering the answer, and I'll give a little bit of detail of what actually happened in the case or what Nike is alleging, but that other video is definitely a lot more detailed. So let me know if you guys have heard about this case. If you haven't heard it about me, make sure you check out the other case. All right. So we got people trickling in here. Like I said, make sure you hit the like button. Help me out in the algorithm there. And let's go ahead and jump right into the issue that I'm having with Stone Brewing. If you guys watched me last week, you know we covered the case where Stone Brewing won the lawsuit against Miller Coors, super big beer company, and Stone Brewing, on the other hand, was an IP beer company, and they actually won against the big brand. They won $56 million from Miller Coors, or Coors Miller. Is it Miller Coors or Coors Miller? I don't remember. But they won from that Coors, big Coors beer brand. They won $56 million. Stone Brewing did. And to my surprise, when I was doing research for what we should cover on today's live stream, Stone Brewing is actually being sued for trademark infringement. So they won on trademark infringement against Miller Coors, but they're also on their way to trial and being sued for trademark infringement. So I thought the money was going to help them out and make their brand bigger and make them more successful. But it sounds like the $56 million might actually just be paying for this lawsuit that this other company have against them. So who is suing Stone Brewing? Oh, that kind of rhymed. I didn't mean to rhyme, but okay, whatever. Sycamore Brewing is from Charlotte, and they are suing Stone Brewing, who is a California beer maker. And what are they suing them for? They are suing them for trademark infringement. So let me go ahead and show you what they're saying is trademark infringement. If you remember from the case last week, Stone Brewing sued Coors, saying that they copied the Stone trademark because they actually have the Stone trademark, and they were able to win. But Sycamore is now suing Stone Brewing for copying their Keep It Juicy trademark. So let's go ahead and take a look at what they have here. I'm sorry, guys, I don't have the complaint this time, but this is the website. It's a website that put the trademark infringement next to each other, and it has a lot of ads. So I am sorry that we have all these Google ads popping up. All right. So on the left, we have the Sycamore Brewing's trademarks, the Keep It Juicy. All of them say Keep It Juicy, honestly. And then we have Stone Brewing on the right side. And Stone Brewing is asserting that they're not copying them. And not to me, in order to be a violation of trademark, or not to me, but the law, to be a violation of trademark, you cannot use something that is the same or confusingly similar to another trademark. Here, they're using the exact phrase, keep it juicy. Okay, now look at the design. They are using a pretty similar design. They have more boxy lettering up top and then kind of a wiggly, I don't know what you would call this type of script, but a little wiggly juicy to um to depict the juicy. So to me, they do look pretty similar. Go ahead and drop in the chat box whether you think it's similar. If you're watching this on the replay, go ahead and drop in the comment section whether you think this is similar. I do think it's pretty similar. It's honestly the same phrase. So, and then on top of that, the design is very similar. They decided to do a black one, and then one with some yellow in there. And like I said, the font on it is pretty similar. So, even though they just won $56 million from Coors, they also are probably going to be paying this company, Sycamore Brewing, a little piece of that money. So they're probably hoping that Coors pays them as soon as possible. Now, in this case, it hasn't gone to trial yet, but it is on its way to trial. And the judge has given them permission to go ahead and sell the remainder of the beer or the alcohol that is still under this branding. But the court is also requiring that they actually cover up the keep it juicy so that there is no confusion. Sycamore Brewing is concerned that if someone buys a Stone Brewing's beer and they don't like it, then they won't then buy Sycamore's beer, therefore ruining their brand and potentially ruining a future customer. So we have a couple of chats here, so let's address those. We have my father's son. Hey Bree, hi, how are you? Welcome to the live stream. Always showing support in the chat. And then we have Laura Alves. I don't think I've seen that name before, but welcome to the live stream. I think it's very similar. I agree with you. It's the same phrase. So they went on that automatically. So if you watch my Stone Brewing video from last week, it doesn't necessarily have to be the same design or anything of that nature. It just has to be the same or confusingly similar. So even if we take out the design, keep it juicy is the exact same phrase. And then if you add in the design is very similar. Just the way they layer it, the way that they designed the actual wording of juicy, and then the boxy letters more at the top. Okay, and then we have divinity. I think that's how you say it with the hearts. Thank you. Welcome to the live stream. All right. So that is all I had on that. Let me know what you guys think there. I just thought it was very interesting and that I should give an update on this, particularly for the reason that we covered their win last week. $56 million, and they're being sued for the same thing they were upset with Coors doing to them. Now, they're arguing that Keep It Juicy should not even be a trademark because it's too generic, basically, or descriptive. It can describe a lot of beers. And one of their arguments is that there are a lot of different trademarks for beers with the word juicy in it, and the court is not going for that so far. Juicy and keep it juicy is two completely different things, just because there are a couple, I think they said like 70 something trademarks with juicy in it, or bears with juicy in the name, but that's not the same as keep it juicy. That is the phrase, and it has been trademarked, so you can't just go around stealing it. And they should know because they literally just sued Miller Coors. So not a good move for them. I wonder if it's going to actually go to trial or if they're going to settle this. I would recommend for them to settle this because I don't think they're going to be able to say, hey, keep it juicy is not a trademark. And I'm not really sure when they got keep it juicy registered as a trademark. I might look into that. Yeah, so they actually said 27 beers with juicy in the name. So that's really not a lot given the amount of beer companies that there are. Um, for them to go ahead and sell the rest of this beer, they do have to do a $50,000 bond to the court. And then they can cover up the beer and sell the rest of it so that they're not losing money on that inventory that they were not able to sell. So that is enough for the Battle of the Beers. That's what they're calling this case for some reason. Now, let's move on to StockX if you guys don't have any questions. So, if you've been following me for a while, you know that I covered the NFT trademark lawsuits that have been filed by famous apparel brands. So we have Nike, and then we also have Hermes who filed for the Meta Birkin, and then we have Stock or Nike who filed against StockX for the Nike NFTs. Now, for those of you who do not know what NFTs are, they are non fungible tokens. What do they actually do? I cannot really explain that to you, but it's a digital item that you can buy online, and they're supposed to be unique in their coding, and you cannot recreate a particular NFT. Nike and Hermes decided to sue under trademark law to try to protect their brands from people promoting NFTs under their name because they want to be able to make NFTs under their name. So they decided to use trademark law to try to fight this. It's not really easy to win any type of lawsuits for like links or web pages or anything like that as far as like copyright infringement. So they're trying to go after trademark infringement. So basically what Nike is saying is that StockX inappropriately used their trademark in order to sell new items. So they made NFTs and StockX is selling it without Nike's permission. As we know, Nike is a giant brand and they own these trademarks and they presented to the court all of their trademark registrations and how StockX is violating it. Now, on a normal occasion, for those of you who do not know what StockX is, it's basically an online retailer that sells, I think they mainly sell shoes. So you can buy already owned shoes from StockX. And the reason why they're able to go ahead and sell them and use Nike name in that sale is because of the second sale or the first sale doctrine. So since Nike already sold it and made money off it, StockX is now able to go and sell it again and probably make a higher profit off of it because the shoes are unique or a vintage or whatever it is that they sell on StockX. They charge whatever amount for those shoes and people pay it because they really want those particular shoes, either because they're sold out or because they're vintage or whatever it is. So StockX is normally able to sell Nike shoes under the Nike trademark because Nike has already made their profit off of that particular shoe. What Nike is now suing for is because StockX is selling NFTs they claim for the Nike shoe, but that has yet to be proven. Nike asserts that you don't necessarily get the shoe when you buy the NFT. So technically, the NFT is a completely new project and they should be sued under trademark law because Nike should own the right to make anything NFT with the Nike name on it. And they believe that StockX is now violating this right. So they went ahead and sued them under trademark infringement. Today, we're going to go over a little bit of their answer, not the whole thing, because answers to complaints are pretty boring. It's just a lot of denying. We don't know all the facts, so we're going to deny, we're going to deny, we're going to deny. But we are going to talk about their preliminary statement and why they think Nike is wrong for coming after them with this NFT trademark infringement. They don't believe that they made a new product. So let's see what they actually have to say. All right, we have Charles Hittrick, and we are talking about Angela Lansbury. I will be shamed every time you mention that because I still have not looked into it. Been super busy with a bunch of cases and also YouTube. All right, we have Laura. I'm from Brazil, so I don't really know what an NFT. Yes, NFTs are pretty new, and I just explained it a little bit earlier. The actual name for it is the non fungible token. And I really can't tell you what it is either, honestly. It's just a digital asset that is supposed to be unique and unable to copy it. Most people use it for like artwork, music, anything online, really, pictures, audio files, websites. You can use it for websites. It's basically a digital asset that is supposedly not supposed to be remade or people cannot copy it. But when you copy and paste it, you can probably do a screenshot of it, but that's besides the point. It exists on the blockchain. I'm not too familiar with the blockchain, but apparently it's supposed to be something that is valuable and people charge a lot of money for it, which is why Nike is suing because a shoe that they sell on their website, a shoe that Nike sells on their website, StockX is selling NFTs for it for $3,000, but the shoe is actually only $200. All right, we have Charles saying, "No shame, you're awesome." So is Angela. Thank you. And then we have Susan, can't you sell them? Do you mean the NFTs? Yes, you can sell the NFTs, and that's why Nike is suing because you can make so much money off of the NFTs. If you check out my old video, not my old video, but the video I did back in January on the NFT lawsuits of Hermes against this Meta Birkin person and Nike against StockX, you will see, like I said, that the actual shoe for Nike is $200, but the NFT is actually $3,000. And then you can also then sell that NFT to somebody else. So someone might have bought it for 3,000, and then another person for 4,000, 5,000. It can keep going up. Same thing with the Meta Birkins. If you are familiar with Birkin bags, I think the cheapest one is like $7,000 to $8,000. But this man was selling these digital Meta Birkin. So just a little picture of a Birkin bag that was not even a clear picture. It was fuzzy. So we were calling them fuzzy Birkins. And they were selling them for $40,000, and then it will resell for $60,000. So people are making a lot of money off of this. And that's why the big companies don't want for just any person to be able to make NFTs under the name that they've already built their brand off of. So, short answer is yes, you can sell your NFTs. All right, we have Alpha Berry saying Rolex. Okay, let's try this again. If this doesn't work, we might just have to cut off the actual mic and use my computer mic. So, I think we are good now. So let's hope we stay good. So again, sorry guys, it had cut off again earlier. So if you can hear me, go ahead and drop a one in the chat or drop a two in the chat this time to see if it's still working. But yeah, I was on a roll, but no longer on a roll, but we'll hop back on it. So I think some people said it cut off around the NFT about Rolex. Um, let's see. All right, so we talked about the noodle NFT. I'm sorry, we messed it up. We missed it. Okay, so let's just hop right back into what's actually going on in this case of Nike suing StockX. So I don't know if I was muted on this part, so I'm sorry if I repeat what I already said, but you can sell NFTs, and that's the issue that Nike and Hermes is having against these companies that are creating NFTs without their permission because they're using their trademark and they're able to profit off of their goodwill. Because if someone came up with a fuzzy purse and it wasn't called a Meta Birkin, then people probably would not buy it. With StockX, if they came up with just an NFT shoe, probably less people would buy it than the people that actually bought it because they actually want the NFT of the Nike shoe. So, if you guys did not hear the answer to the question that you asked, then please go ahead and ask it again and I'll try to get back to it. But as of right now, we're just going to kind of jump right into the lawsuit and see what StockX had to say about the fact that they're creating NFTs. I'm assuming that is going to be something along the lines of, we have the right to use it. It's fair use. It is first sell doctrine. You've already made your money off of it. So yes, let me see, catch up with the chat. Okay, two. Okay, you guys can hear me again. Thank you. And I'm sorry for it cutting off, but thank you for sticking around. All right, so let's go ahead and hop over onto the complaint and see exactly what they have to say for themselves. Like I said, StockX is a shoe. They sell shoes, resell shoes, that tend to be pretty popular. So I think that's big enough for everyone to see, right? All right. So I'm still having trouble over here on my end. Okay. All righty. So StockX LLC, by and through its undersigned counsel, hereby submits this answer to the complaint. StockX is an online global marketplace that provides its customer access to items of current culture, including coveted stickers, apparel, collectible, trading cards, and accessories, among other products. Customers use StockX platform not only to sell or acquire physical products for consumption, but also to trade such physical products for investment purposes. And so they're adding that little investment purposes on there because I don't think that's originally what StockX was for. I think they're inserting that part for the actual NFTs to show that, oh no, they're just investment into the shoes just in case the value of the shoes go up. Then the person with the NFT would then get their money to go up as well. Because as we go on, you'll see that people have the option to either receive the shoe and the NFT or just hold on to the NFT and let the physical shoe stay with StockX for the purpose of them, the NFT owner, either getting the shoe when they want it or for the value of the shoe to go up, and I guess so that they can sell the NFT. That's what it seems like they're going to try to assert. So let's pop back over and see what else they have to say. Since now all of a sudden StockX is an investment platform, partly. StockX's recent introduction of non-fungible tokens, also known as NFTs, to track ownership of frequently traded physical products is transforming the trading experience on its marketplace by increasing efficiencies and decreasing transaction costs for buyers and sellers. Again, they're going into the fact that, oh, we're selling NFTs so that people can invest in the shoe rather than actually owning the shoe. But I thought that was the purpose of owning the shoe, is to have it either as a collectible or to wear it, or they can sell it again later without it actually being an NFT. All right. So using NFTs in this manner is lawful and violates no legitimate right of Nike or any of the manufacturers of the underlying goods. Nike's claims lack merit, disregard settled doctrines of trademark law, including the doctrines of first sale. Well, again, I said that right. They would try to use the first sale doctrine and nominative fair use, and show a fundamental misunderstanding of various functions that NFTs can serve. So they're basically saying that Nike does not know what they're talking about. But guess what? Nike is a large apparel company that is used to filing these trademark lawsuits. So I think that their lawyers most likely understand the first use doctrine and the nominative fair use, or not the fair use, the first sale doctrine and the nominative fair use doctrine. I'm sure Nike's lawyers know this. They probably wouldn't hire them if they did not have a basic understanding of trademark law. But StockX is basically trying to say that the lawyers don't have a basic understanding of trademark law and that they are allowed to use this name. I would suggest, if you have not watched my previous video, to go back and watch it and see what Nike is actually alleging. I think that this is going to fall more under trademark law than StockX is thinking. Of course, they have to defend themselves. They can't admit that they trademark infringe, but this is going to be a new area of law because NFTs are so new. So, what do you guys think in the chat? Do you think that people should be able to make NFTs under famous marks? And when I'm saying famous marks, I'm saying marks that everybody know about. So McDonald's, Nike, Adidas will not let that fly. But who else do we have? In just any brand that most people know of. Do you think that just anybody should be able to make NFTs under that law or under the NFTs? Or do you think that trademark law should have some type of implication stopping people from profiting off of the hard work or the years of popularizing themselves of these famous brands like Nike? Same thing with the Birkin bag. I don't have $7,000 to throw at a bag, and I definitely don't have $7,000 to throw at fuzzy pictures of Birkin bags. But if anybody should profit money off of those fuzzy pictures, I think it should be the actual person that created the actual trademark. So let me know what you guys think in the chat box. If you are not quite sure what I mean by trademark infringement or anything of that nature, go ahead and drop that in the chat box as well. And if you're watching on the replay, go ahead and drop it in the comment section. Okay, so let's pop back over to the answer. And it says, unlike most online marketplaces, which do not authenticate goods sold on their platforms, StockX uses proprietary multi-step authentication process for every product sold on its platform. This process ensures that items traded on StockX conform to the product description and condition standards advertised on StockX, and that the products offered for sale are what they claim to be and are not counterfeit, defective, or used, meaning StockX's customers can trust the transactions made through StockX are safe. But I don't think Nike is saying that they're not. I don't think they're saying that you're selling faulty products. They're saying that you're copying our trademark by making NFTs for our shoes without our permission. Okay, we have Daz Beat. Welcome back to the live stream. Thank you for joining. Some brands are more identifiable than others. I definitely agree with you, and Nike is one of those brands. I think that they should have their trademark protection. All right, and then we have That Sounds Ridiculous to Me. Are you referring to the trademark and if the NFT should be considered trademark infringement? What? Elaborate on that a little bit, Daz Beat. All right, so going back to the actual answer, what do you guys think so far? I think that this intro is a little irrelevant because they're not saying that they're selling fake products. They're saying you're stealing our trademark by making a new product under our name. Okay. So StockX has authenticated tens of millions of products since its formation, combining its authentication team's expert knowledge with AI enhanced technology to allow global customers to trade with confidence. While StockX's authentication process is critically important, it does not come without cost. Upon each sale, the seller ships the products to one of StockX's 11 authentication centers around the world. StockX then performs its multi-step authentication process, and StockX then ships the product to the buyer and ensure that the seller is paid. As a practical matter, this means that for each subsequent trade of the same item, consumers not only incur costs and fees associated with multiple legs of shipping and authentication, but also experience delay in ownership and payout until the process. I don't think that that gives them the right to then make NFTs. So you're basically saying that you're saving the customer money by not actually shipping the products places. So basically, if you want to sell on StockX, you will sell your shoe, put it on the website, you send it to StockX. But if I'm correct, if I understand the way that these websites work correctly, when you sell the item, you don't send it to StockX immediately. You once someone buys it, then you send it to StockX. Okay. And then they can do the authentication process. And if it's real, then they send it to someone else. So what this would require, in my opinion, would be someone wants to sell a shoe. So they have to send it to StockX. StockX will then authenticate it. And then StockX will then need more space in their warehouse in order to hold these shoes because they're not going to give it to the person that buys it. They're just going to deliver the NFT card to them, which is weird. Or the person that's selling it can actually hold on to the shoes and then Nike gives the NFT card to them. But I thought the whole purpose of collecting shoes was to actually have the physical shoe, not just to profit. Correct me if I'm wrong. I'm not a shoe collector. All right. So we have Dabs Beat saying it's the intellectual property of the producer of the good that's represented in the NFT. In this scenario, Nike made the shoe, promoted and advertised it, and sold it. StockX is selling Nike's IP. I agree with you there. They're trying to say that the NFT is not a completely new item, though. They're saying the NFT is only to sell the old Nike item, but that's not true because people are buying the NFT for the $3,000 versus the shoe for the $200. So I can't agree with them on that. I would love to see what type of evidence they produce on that, but right now I'm not convinced. And maybe it's because I want to protect the trademark and the integrity of the trademark, but right now I'm not convinced that they're not stealing Nike's IP. All right, so as a practical matter, this mean did I already read that part? I don't think so. As a practical matter, this means that let's share it so you guys can read along. That each subsequent trade of the same item, consumers not only incur costs and fees associated with multiple legs of shipping and authentication, but also experience a delay in ownership and payout until the process is complete. So they're basically trying to save themselves money so they don't have to keep shipping it out. They can just hold on to it while still making money off of the item until someone actually wants the physical item. For many reasons, including StockX's reputation as a place to purchase authentic products, as well as the incorporation of stock market like mechanics inspired by the world's financial exchanges, StockX's platform has attracted a significant number of customers who are interested in acquiring and trading current products. All right, they're not talking about the NFTs. Let's go on to the NFTs. So we'll skip the rest of that and come down to what's actually happening with the NFTs. To innovate and expedite the process of trading physical products, StockX recently turned to NFTs. NFTs are traded on a blockchain, which permanently stores records for each NFT transfer visible to all users in the network. In contrast to most NFT projects to date, which consist of digital images, including JPEGs and GIFs, created for the metaverse, with or without additional utility attached. StockX Vault NFTs are one of the first NFT applications tied to a physical product. So this would be what Alpha was saying. Um, his NFT is tied to his physical product of the Rolex. StockX is trying to say that their NFTs are tied to the physical product of the shoes that they're buying. But at the same time, like I said, I'm not buying it. I feel like even you have to authenticate it because you can't just sell an NFT for a product and not give it to the people and never find out if it's authentic or not. So at some point, someone will have to send them the shoe. They would have to authenticate it and either hold on to the shoe or send it back to the person. So whatever they might do. I don't know what their process is, but it's not making sense for me. All right. So let's pop back over. All right. StockX's Vault NFT program enables secondary trading on StockX to be more efficient, track ownership of goods, and cut out unnecessary costs and fees to customers. StockX Vault NFTs are absolutely not virtual products or digital sneakers. Rather, each Vault NFT is tied to a specific physical good that has already been authenticated by StockX, but you cannot do that without Nike's permission. If Nike doesn't want NFTs, you can't just start making NFTs because you want to. Consumers purchase the Vault NFTs and have two choices regarding ongoing possession: retain digital possession of the Vault NFTs or leave the authenticated physical good in StockX's climate control high security vault, a stored item, or take possession of the physical good from the vault at any time, in which case the vault NFT is removed from the customer's digital portfolio and permanently removed from circulation. The vault NFT itself has no intrinsic value. It is effectively a claim ticket or a key to access underlying stored items. nor can the vault NFT be traded separately or decoupled from ownership by the underlying stored item. As explained on StockX's product pages, a vault NFT represents and tracks proof of ownership of the actual sneakers stored within the StockX vault. The actual product of value is the underlying store item, and there is no markup for actual vault NFT. While StockX sets the initial price for the vault NFTs, StockX did not set or control prices for subsequent trades, which are dictated completely by StockX users. I feel like it's a good explanation, but I don't know if it's going to hold up against trademark law, because they're trying to use it as the old or for the actual physical product. But I think that Nike will have to put that out for themselves. I don't think that StockX can just make them NFTs without Nike's permission. Hence, like Rolex. Rolex puts the NFT with their actual shoe. If Nike wanted NFTs to be attached to their shoe, then they should put it in the box with their actual shoe. But Rolex with the actual watch, sorry. Sounds like they're gonna pony up some cash. Sounds that way to me too. I see what they're trying to do. I see what they're trying to spin it like, but I'm not on their team. Let me know if you guys are on their team. Do you think should they be able to make NFTs without Nike's permission in order to tie it to the product? The benefit of taking possession of the vault NFT rather than a stored item is that the owner can make a future trade without incurring transaction costs, delay, or risk of damage or loss associated with shipping physical sneakers to StockX and then to the ultimate recipient. So the only people that benefit in this is the people that's actually buying the sold shoe, not necessarily the person that sends the shoe in. Okay. Instead of the owner need only to transfer the vault NFT, which can be performed almost instantaneously through the internet. The stored items remain safe in StockX's vault, and the transfer of ownership to buyer is immediate. Because the stored item never leaves StockX vault, the product does not need to be authenticated again. This novel process is ideal for a growing group of consumers who already make up a significant portion of StockX's customer base, who trade current culture products and do not want to take physical possession for use. I think that's smart. I think it's a smart idea. I just don't think that they're allowed to do it without Nike's permission. I would love to see how the court decides on this. Now, this case is actually different than the Meta Birkin case. The Meta Birkin case is actually them creating pictures of Meta Birkins. It's not tied to a physical product or anything like that. So StockX, I think it's a smart argument. I am not sure if it's going to work because it is such a new thing, but I think the federal courts will be inclined not to allow something like this to happen. If Nike wanted NFTs to be associated with their shoes, they should put it in their box or on their tag or whatever it is, just like Rolex NFT that Alpha has was in the box with his watch when he got it. So I don't know if StockX made the right move right here. I think it's a smart idea, but is it trademark infringement? I would think so. I can see how they're trying to tie it to the first sale doctrine, though, as well. But is it going to work? That's the question. To date, StockX has released vault NFTs associated with 28 different types of physical products, including sneakers, trading cards, and collectibles. 11 of these products are styles of shoes originally manufactured and sold by Nikes, Adidas, and Pumas. In selecting the style of shoes and include the Vault NFT program, StockX looked to best-selling products of which sufficient quantities in a certain shoe size were available for purchase. Example of vault NFTs and stored items that StockX offers for sales are included below. So we're going to get into the pictures of the NFTs that they're offering. So first of all, we have this Adidas Yeezy boot, and it's currently $272. They also have LaMelo Ball Rick and Morty's for $240. They have the Nike Dunk Low Retro White and Black For the highest bid is $375, but the ask is $410. And we have Steph Curry, I guess is a trading card, for $380. So this is what they're saying that they have the NFTs for. And so basically, if you buy this from StockX, you will get a digital NFT in your little, I guess, StockX portfolio, and you will then own the card, but you don't actually have to take physical possession of the card. I don't know if I would count that as an NFT though, because then if someone tries to resell it, they said that they completely get rid of the NFT. Wouldn't it still be the same? I guess they can just create a new one, but it's the same card. I don't know. NFTs are confusing. Okay. As shown above, each vault NFT prominently includes the StockX trademark, and as does the product page where physical goods are offered for sale. In addition, much like a product page or advertisement or any other e-commerce site, Vault NFTs accurately depict and describe the underlying physical product that the consumer is purchasing. For example, the Vault NFT for Nike Low Dunk Retro White Black shows an image generated by StockX of the stored item held in StockX's vault and the relevant product name, because the owner of the stored item need not initially receive the physical good, but can subsequently use the Vault NFT to transfer title to the stored item. The image and the product name on the Vault NFT play a critical role in describing what the goods are actually being bought and sold. Further, the product page of each Vault NFT displays a description of how StockX Vault NFTs function, as well as a disclaimer of any association or affiliation with the product brands, which is depicted below. So this is one of the issues that Nike had with the Vault. One of the things that their disclaimer says is that, oh, we're not really associated with Nike. It's just basically a resale. However, that print is so small and hard to find that it becomes a trademark issue. In addition to that, some of the advertisement includes that sometimes you cannot trade the NFT for the physical product because sometimes they don't actually have the physical product. So let's see how StockX goes ahead and says that this disclaimer saves their butt. So, and I'm sorry if I am glitchy. It is raining out here and I do need to get my Ethernet cord. So it's telling me that my Wi-Fi is not that great right now. So buy StockX Vault, a token for physical pair in our vault. All NFTs goes to StockX portfolio. Redeem a physical pair stored in the vault. For the purpose of the vault NFT is solely to track ownership and transaction in connection with the associated product. The associated product is subject to StockX's own authentication process. The vault NFT is not affiliated or associated. Look how far down that is. With Nike or any of its subsidiaries. Any Nike names used trademarks are the property of Nike. And for more information to go to Nike.com. But like I said, look how small it is and look how far down on the page it is. So that could be an issue. Let's see how much this has. Okay, it's almost done. Okay, so at every point in the process, consumers are made aware that they are purchasing a physical good that StockX has authenticated and that StockX is storing such physical good in its vault. That such physical good may be traded via blockchain and tracked using a StockX branded vault NFT. And that's the issue. It's a StockX branded NFT. It should be a Nike NFT if they're going to have Nike NFTs, or Adidas, or whoever else they claim that they made NFTs for. And that the Vault NFT may be redeemed for physical goods themselves. To date, consumers have enjoyed their experience, successfully completing 2,853 Vault NFTs transactions through StockX's website since the Vault NFT program was launched. Consumers have therefore recognized and will continue to recognize that StockX Vault NFTs are cutting-edge technology to revolutionize the trading and authentication of physical goods. No one has been or could be confused as to the source. Nike's complaint is nothing more than a baseless and misleading attempt to interfere with the application of new technology to the increasing popular and lawful secondary market for the sale of its sneakers and goods. Nike's position is that the resellers of the products are legally prohibited from accurately describing the physical products they seek to trade in a digital world, contrary to trademark law. StockX's use of images of Nike sneakers and descriptions of resale Nike products in connection with StockX bought NFTs is nominative fair use. Okay, I see where they're going with this. Honestly, I do see where they're going with this. They might be able to do something with this, but at the same time, I'm not on their team about it, but they might be able to get away with it. So, sounds like they're trying to design their company to sell NFTs like the brokerage sell future contracts tied to commodities. Unfortunately, a Nike sneaker is not a commodity. They're saying it is to them because people do buy the sneakers for a collectible, but I think that most people want it actually in their position. They're not buying a stock that they're just hoping goes up in value. I feel like a lot of times people actually wear it, but what they're asserting is that they have a community that follows them or that works with them that only wants the value of the shoe. So they don't actually want the physical product. So that's why NFTs make sense for their particular company. However, the trademark, I see what they're trying to do with the first sale doctrine, that they're just reselling an item that already was sold by Nike. But the issue is that they're not necessarily giving the physical item to the person. They're just giving them an NFT, which technically is a new product. The NFT is supposed to be considered a new product. What they're arguing is that it's not a new product. So I see what they're trying to do. But since it's such a new area of law, I really don't know what they will do. So I'm definitely going to keep up with this case to see what the court decides. All right. It is no different than major e-commerce retailers and marketplaces who use images and description of products to sell physical sneakers or other goods which consumers see and are not confused by every single day. Nike's suit threatens the legitimate use of NFTs not just by StockX but by other innovators that also use NFTs to track title to physical goods held in a vault, such as fine art, whiskey, and wine. The use of NFTs to digitally track ownership of physical products is not only lawful but also increases efficiency decreases costs to consumers, promotes sustainability, and should not be disturbed. Okay, I see what you guys are saying. Except to otherwise expressly admit herein, StockX denies each and every allegation contained in the complaint, including without limitation any allegations contained in the preliminary statements, headings, subheadings, footnotes, or incorporated images within the complaint, and specifically denies any liability to Nike. Pursuant Rule 8 of the Federal Rules, allegations in the complaint to which non-responsive pleading is required shall be considered denied. StockX expressly reserves the right to seek leave to amend or supplement the answer. All right, and so this is where they get into all of their denials. What do you guys think in the chat? Let me know what you think in the chat. If you're watching this on the replay, let me know what you think in the comments. I think it's a smart defense. However, I don't think that they should be able to make their own Nike NFTs without Nike's permission or any of the other brands that they claim to have used. So let me just pop on down the complaint because here they're just kind of denying everything that Nike says or admitting in part, and we're not going to go through all of that. So we're going to go down to what their defenses are, because they're saying that they didn't commit any violation of the causes of action. So let's go to see what defenses they plan on asserting. Affirmative defenses. Once I get there. So long answer. That's cause of action still. All right. Affirmative defenses. Let's check it out. What is their defense to this violation? StockX sets forth below affirmative defenses. Each affirmative defense is asserted as to all claims asserted against StockX. By setting forth these defenses, StockX does not assume the burden of proving any fact, issue, or element of the claim where such burden properly belongs to Nike. StockX does not in any way waive or limit any defenses that are or may be raised by its denials or avertments. These defenses are pled in the alternative to preserve the rights of StockX to assert each defense and are without prejudice. So basically just reserving their rights. So the first thing that they are saying is an affirmative defense is a failure to state a claim. Here they're basically saying that Nike has no lawsuit, so you should just dismiss this lawsuit right now because they have failed to state what their actual issue is, because in their opinion it does not violate any trademark laws, and that was the basis of most of Nike's allegations. Next affirmative defense is Nike claims are barred in whole or in part as an act of StockX alleged in complaint constitute descriptive fair use or nominative fair use. So they're saying what they're saying with the fair use. They talked about it a little bit earlier. Is that they are allowed to use the name Nike to describe what they are selling. And since they're selling secondhand things, they are able to use Nike's trademark in order to sell it. We have to see that defense will be relevant or okay if the court finds that they are technically not creating a new product by selling the NFT, since it's attached to a physical item. All right, third affirmative defense is the first sale doctrine. We talked about that a little bit earlier. Basically, Nike already sold it. Let's see what they actually say. Yeah, so they can lawfully allow purchasers of lawfully purchased goods to use the trademark displayed to show people what they're actually selling, similar to the fair use. Okay, no injury. They're saying basically that Nike has not been injured by the fact of them selling this NFT, so they are not entitled to any money. Failure to mitigate. They think that Nike should have reached out to them first before filing this lawsuit. Adequacy of the remedy at law. They any damage by the alleged injury or damage suffered by Nike, if any, would adequately be compensated by damages, basically saying that if they did somehow violate Nike's rights, then they could just pay them and all the troubles will go away. So there's no real reason to have injunctive relief. So injunctive relief is just basically to stop people from doing something by court order. So that is all in this lawsuit. What do you guys think? I think that it's going to be pretty difficult for them to go ahead and show that this is not a new product, because an NFT is considered a product in itself. I think that they have a better chance of surviving this than the Meta Birkin guy, because they are tying it to an actual physical product. The problem that they are going to have is that on their website, it said sometimes they may not actually have the physical product. In this answer, you saw them show one Nike shoe, but on the complaint, they showed several Nike shoes. I can't remember the exact amount, but what StockX is saying that they only have 11 of shoes, and that includes 2 other brands. So of course, they'll do more discovery to figure out exactly what is being sold and under what name and how it's being marketed and if there's physical products. But I think they're toting the line of trademark infringement, because I do think that the NFT is a new item, and that will be something that the court will have to determine. As far as the Meta Birkin goes, I would love to see their answer, because at this point, I do not think they have any defenses. I think StockX might, because they were both filed around the same time. The Birkin bag and this Nike lawsuit were both filed around the same time. Like I said, I think that they're on to something, but I don't think that it's a really good argument, a really strong argument. It's going to be for something that the court is kind of deciding for the first time. So let me know what you guys think. That is all I have for today. I actually have to go soon. So thank you for watching the live stream, and I will catch you next week I don't know what I'll be covering, but I'm sure something will pop up over the weekend. So see you guys later.